Hey, welcome to The Explainer. Today, we're diving into a huge rule of law that you've probably seen in 100 courtroom dramas, one that can literally make or break a criminal case. It's all about who gets to tell the story and why. So, picture this. You're in a courtroom. The key witness is on the stand. The entire case hinges on one piece of information, and their mind goes completely blank. They just can't remember. So, what happens now? Is the whole case just over? All right, let's break this down with a really simple scenario to see how this works in the real world. Let's call it the case of the forgotten license plate. Okay, so here's the play-by-play. There's a crime, and a witness sees the getaway car's license plate. Perfect. They run over to a police officer and tell them the exact number. The officer writes it down. But, trials can take months, even years. By the time our witness gets on the stand, that number is totally gone from their memory. The solution seems pretty obvious, right? Just put the police officer on the stand. The officer heard the number straight from the witness. They can just tell the court what the witness said. Simple. Problem solved, right?
Well, this is where things get interesting, because in the eyes of the law, the answer is often a hard no. And it's all because of a powerful and honestly pretty confusing legal principle called the rule against hearsay. This is what turns our simple yes into a major legal headache.
So, what in the world is hearsay? At its heart, it's just secondhand information. In our case, the officer testifying about the plate number is a classic example. The court isn't being asked to believe that the witness talked to the officer. They're being asked to accept what was said, the license plate number, as a proven fact, and that's a huge leap of faith. A really good way to get your head around this is to think about that game of telephone we all played as kids. One person whispers a message, and by the time it gets to the end of the line, it's totally different. The legal system is terrified of that happening when someone's freedom is on the line. The court's distrust really boils down to a few key issues. First, when the witness told the officer the number, they weren't under oath. Second, the jury never got to see them say it. Were they confident, scared, unsure? But the real deal breaker, the absolute biggest problem, is that the original witness can't be cross-examined about that statement. And see, cross-examination is everything. It's the legal system's built-in quality control. It's how the defense can test a witness's story. They could ask the original witness, how far away were you? Was it dark? Were you wearing your glasses? You can't ask the police officer any of those questions. All the officer knows is what they were told.
Okay, so that's a license plate. Let's raise the stakes a lot higher. What happens when the clue isn't a string of numbers, but a human face? The same rules apply, but boy, do the arguments get more intense, because the potential for a mistake is just so much more dangerous.
This shows you just how fine the line is. On the left, it works. The witness says, I remember picking him, and the officer confirms it. The officer's testimony just supports the witness's memory. But on the right, if the witness has no memory, the officer is trying to replace that memory entirely. And that's our classic hearsay problem. Okay, but what about this? This is where it gets really murky. Let's say the witness gets on the stand and says, look, I remember the lineup. I 100% pointed to the guy who did it, but looking at the defendant today, I just can't be sure it was him. Can the officer now step in and fill in that blank? This is the kind of gray area that judges argue about all the time.
And yeah, this very question has split some of the sharpest legal minds. You've got one judge arguing that the officer's testimony isn't hearsay at all. It's what they call original evidence. It just gives meaning to the witness's action. Then another judge comes at it from a different angle, saying the officer is just describing an act they saw, the physical act of pointing, which isn't a statement. It's a fascinating legal debate.
So what this all really boils down to is this constant push and pull. On one side, you have the need to get valuable, important evidence in front of a jury. But on the other, you have this fundamental right for an accused person to face their accuser and challenge the evidence.
Which of course brings us to the big question, why? Why all this complexity? Why would the system risk letting a crucial piece of evidence get tossed out on what feels like a technicality? Well, the answer comes down to what we're willing to pay for fairness.
And this quote from a major ruling really hits it home. It basically says that the rule against hearsay is that important. It doesn't get a special exception just because we're talking about something as critical as identifying a suspect. The risk of getting it wrong is just considered way too high. Now, even if a judge decides to let some of this testimony in, it comes with a huge warning label. The judge has to turn to the jury and be very clear.
They have to say, listen, you have to remember this was never tested by cross-examination. You never got to see the person who originally said it. You need to look at this evidence very, very carefully.
So, when you strip it all away, the reason for this incredibly complicated rule is actually pretty simple, and it's powerful. It's the belief that the risk of sending an innocent person to prison based on an untestable, secondhand story is just too great a risk for the justice system to take. And that leaves us right here with this central question. We all know memory is a tricky, fragile thing. So when it fails on a witness stand, how much trust should our legal system really place in the echo of a story? It's a question that courts have to wrestle with every single day.